Land trust versus LLC. Which one actually protects you? Most real estate investors pick one of these two structures, and most of them pick wrong. Not because the structure is bad, because they don't understand what each one actually does. So let's fix that right now. Here's the question most people ask: should I hold my property in a land trust or an LLC? And the honest answer is, that's the wrong question, because these two tools don't do the same thing at all. Let's start with the land trust. A land trust is a legal arrangement where a trustee holds title to your property, but you, as the beneficiary, maintain full control. Your name doesn't appear on the public deed, the trustee's name does. That's the whole point: privacy. Think about what that means in practice. Right now, anyone, a tenant, a lawyer, a stranger on the internet, can go to your county recorder's website, type in your name, and pull up every piece of real estate you own. Your address, your other properties, your entire portfolio, visible to anyone in 30 seconds. A land trust changes that. When a creditor searches for the title, they see only the trustee's name, not yours. You become invisible on paper. And when lawyers are looking for defendants, they tend to go after easy targets. If they can't find you, they're less likely to come after you. The key distinction: a land trust is not to be confused with a living trust. A living trust helps your heirs avoid probate when you pass away. A land trust keeps your name off public records while you're alive and still own the property. Two completely different tools. But here's where people get into trouble. A land trust does not provide liability protection on its own. If someone gets hurt on your property and sues you, the beneficiary of that trust is still on the hook. The land trust hides your identity. It does not shield your assets. That's the trade-off: privacy without protection. Now let's talk about the LLC. An LLC, a limited liability company, is a business entity that legally separates your personal assets from your real estate investment. If the property faces a lawsuit or debt, only the LLC's assets are at risk, not your personal bank accounts, not your home, not your savings. That's powerful. That's real protection. But the LLC has its own blind spots. If you look up an LLC at the Secretary of State website, you can find the owners. And if the registered address is your home address, congratulations, your home address is now public record. So you have asset protection, but zero privacy, the opposite problem from the land trust. Now here's where it gets interesting, and this is what most people online don't talk about. There's a third option. And it's the one serious investors actually use. You layer them together. The real estate goes into a land trust. The LLC becomes the beneficiary of that land trust. You control the LLC as the managing member. The public sees only the trustee's name, not yours, not your LLC's. And if a lawsuit arises, the claim targets the LLC, protecting your personal assets. One structure gives you privacy, the other gives you protection. Layered together, you get both. Now let's talk about something that almost nobody explains clearly: the due-on-sale clause. Most mortgages contain a due-on-sale clause, a provision that allows the bank to demand full repayment of the loan if the property is transferred. This is the clause that makes a lot of investors nervous about moving their properties into any structure at all. Here's what you need to know. The Garn-Saint-Germain Act of 1982 protects transfers into a living trust where the borrower remains the beneficiary and occupant. But it does not automatically protect LLC transfers. An LLC is a separate legal entity, and transferring your property into one can technically trigger that clause. However, and this is important, about 70% of all mortgages are backed by Fannie Mae or Freddie Mac, and both allow transfers to an LLC under certain conditions. The mortgage was purchased after June 1st, 2016, and the LLC is controlled by or majority owned by the original borrower. And practically speaking, historically, mortgage lenders have been reluctant to accelerate a performing loan on purely technical grounds. Banks want to get paid. They don't want to start a legal fight over a technicality with a borrower who hasn't missed a payment. That said, always check with your lender and your attorney before making any transfer. Don't guess. So, what's the right move for you? If you have a mortgage on an investment property and your main concern is being sued, an LLC gives you the protection you need. If you want to keep your name completely off public records, a land trust gets you there. But on its own, it won't protect you in court. And if you want both, layer a land trust with a Wyoming LLC. The trust keeps your name off the title. The LLC shields you from liability. Together, they create a legal firewall that discourages lawsuits because attorneys prefer easy targets, and you won't look like one. One last thing, don't overcomplicate this. Some investors create a separate LLC for every single property, which adds up fast. Make sure the cost of the structure makes sense for the value of what you're protecting. The right structure isn't one size fits all. If this is confusing, that's normal. This is exactly the kind of decision worth sitting down with a real estate attorney before you file anything.